Law inconsistent with fundamental right or void. Explain what is the fate of the law which are inconsistent with or are in derogation of the fundamental right. The rule of law. The rule of law is the rule of law. The rule of law is the rule of law is the bedrock of the democracy. The rule of law is the bedrock, BADROCK, bedrock of democracy, and the primary responsibility for primary responsibility for implementation of the rule of law lay within the judiciary. Lay within the judiciary. Full stop. This is now in a basic feature of every basic feature of every constitution which cannot be altered even by the exercise of new power from parliament. It is the signification of the judicial review. It is signification of the judicial review to ensure that democracy is inclusive. Democracy is inclusive and that there is that their rule of law is bedrock of the democracy. The rule of law is bedrock of democracy and the primary responsibility for implementation of the rule of law lay within the judiciary. Full stop. This is now in a basic feature of every constitution which cannot be altered even when the exercise of the new power from parliament. Full stop. It is the significance of judicial review to ensure that democracy is inclusive and there is accountability of everyone who widles over exercise power public power. Judicial review is the power of the court to prominence province upon the constitutionality of legislative act which fall within their normal jurisdiction to enforce, and the power to refuse to enforce such as they find to be unconstitutional and hence void. Judicial review, said Khanna Khanna J in the Fundamental Right case number 2, as this become an integral part of our constitutional system and a power has been vested in the High Court and the Court Supreme Court to decide about the constitutional validity of the provision of the statute if full stop if the provision of the statutes are found to be violative of any of article of the constitution which is the touchstone for the validity of all of the law. The Supreme Court and the High Court are empowered to strike down the said provision law inconsistent with or in derogation of the fundamental right. Law inconsistent with or in derogation of the fundamental right. All, all law in force in the territory of India immediately before the commencement of this constitution, in so far as they are inconsistent with the provision of this part, shall be extend to such inconsistency to void. Inconsistency be void. Inconsistency be void. Full stop. The state shall not make any law which take away or abridge abridge the right conferred by this part, and any law made in contravention of this clause shall be the extent of the contravention be void. Contravention be void. 3. In this article, unless the context otherwise required, law including any audience under by law, rule, regulation, notification, custom, or uses having in the territory of India Territory of India, the force of law, law in force including law pass or made by the legislature or other competent authority in the territory of the India before the commencement of this constitution and not previous repealed, notwithstanding that any such a law or that any such a law in any part thereof may not be then in operation neither at all over in particular area for nothing in this article shall apply to any amendment of this constitution made under article 368 right of the equality 368 right of equality Article 13 Clause 1 existing law inconsistent with the Constitution. Article 13 Clause 1 existing law inconsistent with the Constitution. This clause provide that all law in force at commencement of the Constitution which class within the exercise of the fundamental right conferred by the part third of the constitution shall to the extent to be void but this does not make the existing law which are inconsistent with the fundamental right void be in initiative full stop the enter part third of the constitution including art 13 clause 1 this prospective hence existing law which are inconsistent with any provision of the part third are retended are retained void only with effect from the commencement of the constitution which for the first time created the fundamental right but if the proceeding had been become final before the commencement of the constitution nothing in the fundamental right of the constitution can be operate retrospective so as to effect whose proceeding full stop for the same reason it is not possible to impeach the validity of that part of the proceeding which had been taken place under the inconsistent law prior to the commencement of the constitutionality of the pre-constitutional order. Pre-constitutional order 1. Provision of the part third of the Constitution having no retrospective effect. Any action taken under any law which was valid at the time when such action was taken prior to the coming into the force of the Constitution cannot after the commencement of the Constitution be challenged as unconstitutional on the score of it infringing any of the fundamental right. Clause 2. Post constitution law which are the inconsistent shall be void be in situ void be in situ हो गया void be in situ shall be valid this expression shall be void this expression shall be void occur in the clause 1 and clause 2 it full stop it does not appear that in inconsistent law become void without any declaration from the court to that effect full stop a citizen who is possessed of the fundamental right and whose right has been infringed can apply to the court and relief upon in declaration that the law is inconsistent with the constitution consistent with the constitution. Clause 4 article 13 not be applied to a law for amendment of the constitution. Clause 4 article 13 not be applied to a law for amendment of the constitution. Clause 4 was inserted by the constitution 24 amendment act 1971 with effect from the 5/11/1971 to override the view taken by the Sabha Rao CJ Sabha SUBB Sabha Rao SJ for the majority in Golaknath GOLAK Golaknath versus State of Punjab, that in a Constitution Amendment Act passed according to the Article 368 is in a law within the meaning of the Article 13 and would according be void void if it contravening a fundamental right. Full of this amendment was declared void in Minerva Minerva Mill case हो गया Minerva Mill case in L Chandra Kumar versus Union of India. A large batch of the 7 judge unequivocal declare full that the power of the judicial review over legislative action vested in the High Court under the Article 226 and in the Supreme Court under the Article 32 of the Constitution is an integral and essential feature of the Constitution, a constituting part of its basic structure. Right note on the doctrinal lapse. Doctrine of lapse हो गया आच्छादन का सिद्धांत. It is applicable to the post constitutional law. Post constitutional law. Some law are held unconstitutional by the court. What does that mean, and do you remain in the book of the statute or the immediately removed from them? The legal position that remain is that thought the law exists in statute book and because of a decision they are inoperable. Full stop. Only the parliament has the power to bring any amend in the statute so until and unless any amendment is brought they remaining in book ellipse full stop. There in a law there is an ellipse cast upon their implementation. Doctrine of the ellipse deal with pre-constitutional law in Article 13 clause 1. 13 clause 1 हो गया. Article 13 provide that any law which was made therefore the commencement of the Constitution must be consistent with the part 3rd of the Constitution. If any statute is inconsistent with the provision of the part 3rd of the Constitution, such statute shall become void. At the same time, such statute shall not be treated as a dead unless it is abolished by the parliament. Full stop. It will be created as a dormant or remaining lips to the extent it become under the shadow of the fundamental right. Shadow of the fundamental right, it is held to be applied only the pre-constitutional law, not be in post-constitutional law. Example. For solving such a problem, Supreme Court formulated the doctrine of ellipse in Bikaji versus State of MP. Bikaji versus State of MP हो गया. Bikaji versus State of MP. In this case of the provision of the CP and barrier motor vehicle Barrier Motor Vehicle Amendment Act 1948 authorize the state government to take up of the enter motor transport vehicle business in the provision to the exclusive motor transfer operator हो गया. Transfer any if any sufficient amendment to the Constitution remove the inconsistency or the conflict of the existing law within the fundamental right, then the ellipse wins and that particular law against become active against. Particular law acting against हो गया only with respect to the exercise of the fundamental right on and after the date of the commencement of the Constitution हो गया. Doctrine of ellipse हो गया. Doctrine of ellipse, it is only has against the citizen that they are remain in a dormant हो गया. Dormant